right? If we see how it's recording now and it says
Yeah.
play. So you. Okay. It's about 1:05 p.m. We'll go ahead and kick this off. I want to say thank you to everybody who is on the line right now. You all are muted. If you'd like to unmute yourself, I believe it is on. If you're on the phone, I believe you just press *6 and you'll be unmuted. This will be preferenced a little bit more towards the folks who are on the computer and are able to see the screen share for today. So if you are unable to unmute yourself on the phone, I think we only have 1 or 2 people. It looks like 2 people on the phone. So unfortunately, you may not get your question in. But for those of you who are on your laptop or smartphone and are able to see the chat and the video, go ahead and put your questions throughout the course of this webinar in the chat. I will be monitoring them, and I will let CJ know if there are questions that need to be addressed throughout the course of the webinar. Now that the housekeeping is out of the way, let me welcome you all to this webinar about New Jersey's Open Public Records Act, often known as OPRA. You are going to be led today by the wonderful CJ Griffin. I'll let CJ introduce herself in a moment. This is a webinar put on by the Center for Cooperative Media. My name is Joe Amditas, and I am the Associate Director of the Center for Cooperative Media at Montclair State University. We are a foundation-funded, grant-funded organization that focuses on growing and strengthening local news in New Jersey, and in doing so, serving New Jersey residents. I see some familiar faces today, or at least familiar names. Some I don't know, which is always good. This webinar will be recorded, although I would appreciate a couple of ground rules here. One, we need to abide by Chatham House rules. For those of you who don't know, this is a little rule of procedure here where people are allowed to discuss what we've talked about on this webinar externally and publicly, but if you do decide to do that and discuss it publicly, please refrain from attributing any specific statements to any specific people. Again, this webinar is being recorded for posterity and to be shared publicly later. If at any point you wish to discuss something that you feel is sensitive in nature or legally questionable in terms of you don't know whether or not it would be a good idea to discuss it publicly, please let us know or indicate, and I will pause the recording so that it is no longer there. If you hear from your editor later on, oh, you shouldn't have talked about that, please let me know as well, and we can go in and make sure that we don't get anybody in trouble. This whole point of this is to inform our partners on how they can best approach these legal issues, but this is not legal advice, as I'm sure CJ will emphasize very strongly. This is not legal counsel or of any kind. We do just want to make sure that this is a comfortable environment for people to ask open questions and get open answers about some of the things that they'd like to know more about when it comes to OPRA and OPMA. So without further ado, I will turn it over to CJ, and you can go ahead and introduce yourself to the gang here and begin whenever you're ready.
Hi, everyone. Thank you for attending today. I recognize some names of current clients and reporter friends and some new faces as well. So I thank you for attending. I'm hoping that we can go over some cursory information that some of you will know, but some of you might not know, and then delve into your questions. And a bunch of them were submitted in advance, so I will try to answer those. I have screens for them, and then as questions come up, I will hopefully be able to get you an answer to other questions today, or at least take note and get in touch with you personally after the seminar. So this is just a little bit about me. Many of you already know me and the work that I've done, but I've been very privileged to have worked on some of the bigger, well-known OPRA cases over the past 5 years. And I'm constantly always willing to take on a case that might be an issue of first impression, and try to, gain access to a record that we might not have had access to before. So I'm just going to go over a few things today. Again, some of this will be a reminder, a review for some of you, but many of you might be seeing these concepts for the first time. So I'm just going to give some quick tips about how to draft a valid request. There are certain mistakes that I see people make over and over again, and then very quickly discuss how an agency is supposed to respond. I'll quickly go over 2 or 3 of the exemptions that come up the most, and then I'll talk about how you can challenge a denial, and then we'll dive right into the questions that have been submitted via the registration form, and then we'll see if anyone has any other questions. So the first is tips for drafting a request. So the first thing that you should know is that New Jersey, or OPRA applies only to New Jersey agencies. It's not federal agencies. For that, you have to submit a FOIA request to a federal government agency, but it's municipalities and counties and state agencies and independent authorities, and then there's some quasi-public nonprofit organizations that are subject to OPRA, like the NJSPCA was, I won that case, or the League of Municipalities, or other organizations that are really doing government business, but they're nonetheless officially nonprofit organizations. The OPRA does not apply to the judiciary, so we won't be discussing court records today. The judiciary has its own records request process that you have to go through in order to get records from them. And also the legislature is overwhelmingly not subject to OPRA, other than things like budgets and basic documents that they place on their website as well. So how do you draft a valid request? The number one, well, actually, let me just get through a few little things before I go into the valid request part. So this is something that people don't realize. You don't have to use the agency form. It's kind of cumbersome to fill it out completely. You can just shoot the custodian an email that says, hello, I'm seeking, this is an OPRA request. Here are the 3 records that I want. Include contact information if you want to include contact information, but you don't necessarily have to. You can actually create an anonymous Gmail account or some other account if you want to keep your request anonymous. And I have a few clients that do this. Some are reporters that don't want the agency to know that there's a reporter that's seeking this information, because maybe that will tip the agency off that there's some sort of story that might be coming. Maybe they don't want other reporters to request their request and see who is seeking the information. Or maybe it's a citizen or a town employee that just doesn't want the custodian to know who it is that's requesting something. So for the most part, you can request almost all records anonymously. The only ones that you can't are victims' records, but those are sort of this carve out that doesn't generally apply. When you submit your request, though, always make sure you tell them how you want them to respond to the request. So if you shoot the custodian an email that says, I would like a copy of your monthly meeting minutes, make sure you say, please send them to me electronically in PDF form. That way you don't get an email back from her in a week saying, okay, we copied them and that's $1.50 in charges and you have to send a check or come pick them up. And I write here in your request, I always start every OPRA request the same way. I say, pursuant to OPRA and the common law right of access, I seek the following records. And I will talk about why you want to invoke the common law in a couple of screens. But this is sort of the template. It can be an email, and always say OPRA and the common law, and then state the method of delivery that you want. So tips. The number one problem that I see requesters making mistake is, it's not only, I see journalists making this mistake as well, is that people will file a request for information rather than records. So they will send the custodian basically a question, and then the custodian will, sometimes if it's a simple question, might respond and answer it. But often you will just get this form response that's 2 or 3 paragraphs that all the agencies use that says, we are not required to correlate data or provide information to you. OPRA only applies to requests for documents and not information. And it's very frustrating to get that because you have a question that you want to be answered. And so what I always tell people is that what you need to do is, when you're doing your reporting and you have a list of questions that you want to be answered, write down the questions and then think about what type of documents might contain the answers to that question. So for example, you couldn't say, tell me how many police officers used force against suspects in 2016, because that's a question. In order to answer your question, the custodian would have to go get some sort of document and then calculate the number and then tell you the answer. But what you could do instead is say, I would like all of your use of force report forms for the year 2016, and then you get them and review them and tally it yourself. So, how do you find out what records an agency might have? Now, that's the more complicated part. So sometimes you can pick up the phone and call the custodian and say, look, I'm doing reporting on this topic, and I'm not quite sure what records I might have this information. Can you give me any tips? The custodian might have a tip for you, or she might say, talk to the business administrator, or talk to the mayor, or talk to the police chief. There might be a person that's willing to give you a tip on the type of record that you could request pursuant to OPRA. If there isn't, then sometimes you have to do some digging. So you might want to look, some sources would be, for example, police records. If you requested standard operating procedures, you might be able to see that there are specific reports that are required to be made for a specific type of incident. The same for administrative procedures that the agency might have. But basically the most important thing is that you can't ask questions. You have to find a document that answers the question for you, even if it requires you to do some calculation and correlation of data yourself. You also need to identify a specific record. I sort of hate this requirement because you don't always know the specific record, but you might know that there's a specific file. So there's cases that say you can't say, I would like the entire investigation file for Bob Jones, because that's not requesting a specific record. So instead you have to think of, well, what type of records might be in that file? So for a police file, you know, it's going to usually have police reports and incident reports and arrest reports and complaints and other similar records. A zoning board, you know, file would have different types of records, and you have to really think of what types of documents would be in a particular file, because you can't request the entire file. It's a pain, but that's what the case law is. There are some circumstances where you don't have to request you could request a category of records without knowing the specific record at stake. So you could say, I want all settlement agreements between, you know, all settlement agreements for 2018. You don't have to know the specific litigations that those settlement agreements settled. It's enough for you just to say all settlement agreements. So you can also say, I want all use of force reports, or all OPRA requests that were filed for 2018. Because then you're naming a specific document, even if you don't know more information about each particular document within that category. And then importantly, you always want to include a reasonable date range, and reasonable really depends on the type of record and how many responsive records it might produce. So reasonable for settlement agreements for an average agency is probably a year or two. For reasonable for email correspondence is probably less. I did a calculation and I send and receive about 35,000 emails a year. So if you requested a year of my emails, you're going to, you know, you're going to get tens of thousands of responsive records, and then you're going to get hit with a response that's they're going to deny your request because it's too voluminous, or they're going to try to impose a special service charge. So really think about, you know, how many documents might be responsive to your request, and consider narrowing it down. Request a month of email correspondence, and then file a new request as soon as you get that for the next month and the next month, and do it in small batches. So the common law, I said, always make sure you say, I want a document pursuant to OPRA and the common law. Well, for records that are unequivocally subject to OPRA, like payroll records, it doesn't matter so much. But there are a variety of records where it's questionable whether something might be subject to OPRA, or the courts have held it's not subject to OPRA, but that you could still get it under what we call the common law. For the common law, for OPRA, you can get a record for any reason. You can you want a record because you're curious, you want a record because you like stacks of paper sitting on your desk, you can get it for any reason. You don't have to say what your reason is. For the common law, you do. You have to tell them, you know, some interest, either your own personal interest in the record or the public's interest. So dash camera videos of police of crimes or criminal investigations are one such category. The courts have said they're not subject to OPRA, and I'll talk about why in a little bit, but they should be subject to the common law, and the courts will do this balancing test to say, well, here's the agency's need for confidentiality, and here's the public or the requester's need for transparency, and we're going to balance them and determine whether it should be released. Newspapers have sort of a heightened interest, or at least courts kind of view it that way, because you've been held to be the eyes and the ears of the public. So it's always sort of easier for newspapers to explain what the interest in the record is, because you're going to publish a story and let the public know about it. So now, once you've submitted your valid request, then you're going to get a response. And I'm just going to talk about this very briefly, because we'll go into some more of it later during the Q&A part. But an agency has to respond to you for most requests within 7 business days. It's business days, not calendar days, and the days, and you have to, subtract holidays out. And the day 1 starts tomorrow. So if you submit a request today before 5, then it's going to start counting tomorrow. And within that 7 days, it doesn't mean you're going to get records in 7 days. And I'm sure anybody that's on the video or phone that's submitted a request knows how rare it is to get 7-day responses sometimes from certain agencies especially. But they can't just ignore your request. Within 7 days, they have to either give you the records, they have to deny the records and tell you exactly why they're denying each and every record. They have to ask you for a clarification because maybe your response wasn't clear, or maybe you asked a question instead of seeking a specific record. They have to ask, and I use ask in quotations because we'll talk about later why it's really telling you that there's going to be an extension. Or they can ask to impose a special service charge. If they don't respond at all within 7 days, the statute says that's a deemed denial of your request. You can consider it to be denied, but what that means really is that you need to follow up. Courts don't want to see you filing a lawsuit on day 8. Things happen. Custodians, especially at some agencies, get a lot of emails. I've had emails that have been stuck in spam. There's been a time that we sued because the custodian was never responding, and we found out that the fax machine it was going to was broken and was hiding the responses that they were sending. So always follow up. I try to tell people follow up in 2 different methods. One, the email, so that you have a writing showing that you follow up. And then if you don't get a response to that, leave a voicemail or send a fax or do some other form of follow up to make sure that your follow up is getting through and that your request was originally through. There are a few records that you should get immediate access to, the statute says, and they're listed here in the statute, and it's budgets, bills, vouchers, contracts, collective bargaining agreements, employment contracts, and public employee salary and overtime information. And what this means is that you should be able to either walk into the public agency town hall and say, hello, town clerk, I would like to know how much money the mayor makes. Or you should be able to email the clerk and say, this is I always say write in the subject line, immediate access OPRA request, and they're supposed to respond to you within 24 hours. And these are documents that are just not subject to any exemption. So there's no reason that they can't be immediately produced. They're documents that they should have on file. Lots of them should be on websites already, but they aren't always. But you're supposed to get these within 24 hours, not within 7 days. Special service charges are permitted for requests that require an extraordinary effort to comply with. Usually 2 or 3, 4 or 5 hours is not extraordinary. It depends upon the agency. A request that's going to take 5 hours might be extraordinary for a tiny little town in South Jersey that I sued that had 7 staff members, but it's not extraordinary for the city of Newark or any reasonably staffed public agency. I've seen agencies start to use these service charges as a way to get people to go away. You file an OPRA request for some emails, and then you get a response saying that's going to be 49 hours and $400 for us to produce those. So send us a check and then we'll do the work. But usually you can push back on it. You can also respond by narrowing your request some. If you requested 3 months of emails, then say, okay, I'll take 1 month of emails. There's always a way to sort of get around it. Or maybe you really do want that many emails and it will take that much work, and you're a reporter with a news agency that's willing to pay $400 to get these documents because they're so critical to your reporting. So I'm going to quickly go through some exemptions. We'll talk about more of them later. So there's about 25 exemptions in OPRA. And then not only does OPRA itself create exemptions, but records can be exempt pursuant to executive orders or state regulations or federal or state statutes, or even judicial case law. So you can't always tell just by looking at the OPRA law itself if something is exempt, but the agency has to tell you, the burden is on them to tell you why something is exempt. So they can't just respond and say it's denied. They have to say it's denied pursuant to this statute or this case law. And then, once they did the work of telling you why it would be denied, then you can, reach out to someone like me who could tell you whether that's valid or not. So police records is obviously something that reporters especially, request all of the time. There's two main exemptions that apply, and unfortunately the first one sort of swallows almost all police records that relate to criminal investigations anyway. So police records in New Jersey are very hard to get. We're one of the least transparent states. It's kind of embarrassing that a place like Florida is more transparent than New Jersey. But so there's the criminal investigatory records exemption. And what that says is that if a record pertains to a criminal investigation, and that's broadly, if they investigated and didn't find a crime, the courts will still say criminal investigation. And it also is not required by law to be made, maintained, or kept on file, then it will be exempt. Well, that last phrase, required by law to be made, maintained, or kept on file, is really sort of what does police records in, because there are very few records that are required to be made, maintained, or kept on file. I'll show you a screen of them in a few minutes, but for the most part, if there's a criminal investigation, you're not going to be able to get, under OPRA anyway, the police reports or the witness statements or most documents in the criminal file. And to make it worse, there's no time limitation on this. It's the second exemption is only while the investigation is ongoing. The first one is forever. So even if it was 15 years ago and you want a criminal investigation file, they can technically still deny you access under OPRA under this exemption. The second one is for ongoing only investigation exemption. So of the few records that are not captured in the first one, then you move on to the second one and say, okay, well, it's not exempt under the first one categorically, so could the second one apply? It can apply only if it's currently ongoing. It also applies to any investigation, not just criminal investigation. So this would cover, internal like employment investigations or other investigations that like fire department investigations, other investigations the agency's doing that are not done by the police department. And so to withhold this, they have to prove that releasing it would be inimical to the public interest. And what that means is that, much like the common law, there's this balancing test where the court's going to say what is the public's interest in disclosure, and what is the interest in keeping it from the public. There was a period of time where, in OPRA's early days, where it was very hard for agencies to claim this exemption. And then we had this period of time where it was very easy for them to claim it. And I feel like now we're back to the higher standard where courts are seeing the public interest in disclosure more. So, I think it's harder for agencies to apply the ongoing investigation exemption. So here's a little list of what's generally not exempt. 911 calls, CAD reports, criminal complaints, indictments, and summonses that are usually filed with the court. Dash cam videos are exempt under OPRA for the most part, but not under the common law. Body cam videos, crash reports and accident reports, vehicle police reports, pursuit reports. That's when the police officers pursue a car. Use of force reports, police reports that don't relate to a crime, so DWIs, just standard police incident reports that they come out for a noise violation, standard operating procedures, and autopsy reports. Almost always exempt is most of the documents within a criminal investigation file. So you're not going to get a lot of the documents that are exchanged between the state and the defendant, witness statements and video interviews and police reports and all of that. Security camera and surveillance footage, you're not going to get most of that. but they're supposed to consider your interest under the common law. So if you slipped and fell in the parking lot of the municipal building, you probably cannot you probably can't get a copy of the footage under OPRA, but you could say, I need this for a potential court case. Give me that 15-minute video shot of me falling, and they should consider your interest and give it to you. Mug shots, which I know would be surprising to many of you, because police departments release mug shots all of the time, but technically, according to an executive order, they are exempt. So they can selectively release mug shots if it's if it's someone that they don't want the public to see the mugshot of, then they can withhold them, and there's nothing to do under OPRA. Autopsy and photographs and videos are exempt under OPRA's language, not the report itself. And then victims records, which I think is sort of poorly defined in the statute, but they are exempt. So here's another tip, though. So even though most police records are exempt, there is this category of information they have to disclose to you. So this is how the quote at the top is how you would word that request. So you would, if you know that a crime was reported or you know an incident occurred, you can file an OPRA request with the custodian and say, I seek all information required to be released pursuant to NJSA 47 1A 3B, and then remind them it's due, a response is due within 24 hours. So there's two different levels of disclosure. If there was not an arrest, but there was just a report of a crime, then they have to tell you what type of crime was reported, where the crime allegedly occurred, and what type of what. If there was a weapon, and what type of weapon. And that's just a way so that you can know, hey, there was a rape last night on Main Street in Hackensack, and the person had a knife. There's no arrest, but like you can be aware and alert the public that this has happened. They can, be aware for their own safety. If there was an arrest or the suspect is otherwise seized, and I say seized because we litigated an issue where the police shot and killed the suspect, and then they tried to argue that there was no arrest, so they didn't have to tell us the rest of this information, and the court said that doesn't fly. Then they have to tell you the name and address and age of the victims, the name, address, occupation, other information about the defendant, what they're charged with, who investigated and arrested the individual, or in the case of where they shoot someone, who shot the individual, and then other information about the arrest, if there was a police pursuit, if there was any use of force, what type of weapons the police used, or what type of weapons the suspect used. So you should always get that. There can be limited circumstances where they might be able to withhold that information but it would be very limited. And I think that agencies are doing fairly well at not withholding it in general, but they don't always respond to the request within 24 hours. So if you don't get a response back the next day, shoot them an email and say, just a reminder, this information was due to me within 24 hours. You don't have to wait that 7 business days. Personnel records, as I'm sure most of you know, are largely exempt from access, but there's 3 categories of information that you can get. The first one is just general information about the employee, their name, title, position, salary, payroll record, length of service, date of separation, and the reason therefor, and the amount and type of any pension. I have a new case at the Supreme Court about the phrase date of separation and the reason therefor. We argue that it means you're entitled to know why someone was terminated or forced to resign, and the state has argued that you're not, that it just means all you get to find out is separated from employment. And so I can't tell you exactly what that means until the Supreme Court rules on it in probably like a year or so. The second one is where disclosure is required by another law or with the person's consent. That's rare, but what it basically means is someone could request their own personnel records, or they could sign a permission slip for you to request them. And the third one is records which disclose that a person meets a certain meets the educational and experiential requirements of the job. So if it's required that they take specific training, you can request the training certificates. If it's required that they have a specific degree, you can request their resume, and they should leave that information unredacted so that you can make sure that they meet the qualifications. The other one you'll run into a lot is OPRA's privacy provision. OPRA does say that agencies have an obligation to protect someone's reasonable expectation of privacy. Some things are categorically exempt. You can't get someone's social security number or credit card number or driver's license number. But there's other little gray areas where perhaps a record might contain some sort of medical information, or there's been 911 calls that were described as really gruesome and showing someone's dying words, and the courts have held that there was a reasonable expectation of privacy and the public doesn't get those. And then, there's this slate of other exemptions I'm not going to go into in detail, but you will encounter them. Some of them are categorical and some of them are not. Challenging a denial, just quickly, the most important thing to know is that with OPRA requests, time is of the essence. You only have 45 days to do anything about it in court anyway. You can always file a GRC complaint later, but for reporters especially, you want to be in court. So in court, I can take a case for you, and you give it to me today and we'll file it within a week or two, and then the judge is going to sign an order, and we'll be able to go to court and argue before the judge within 6 weeks to 8 weeks, sometimes a little longer for really complicated legal issues, but we can get you a decision in 3 months or less. For the GRC, I recently had a case where they just decided 4 years later. So it takes at least 18 months there. And if you're writing a story, you don't have 18 months to wait. So you want to go to court. So that means you need to act fast. There's only 45 days from the date you get that denial to file a lawsuit. So as soon as you get one, you need to talk to your editor or an attorney, someone that can assist you. Some of my clients are on the phone today, so that you've come to me for this sort of thing. So there's two sort of different services that I provide. Some people will hire me to just draft an objection letter to the agency, and sometimes receiving a letter from me with objections and why I think they were wrong will cause them to release the record, and then you get it sooner. Sometimes they won't cave and we still have to go to litigation. Some people, small publications especially, and freelancers, they can't afford to pay for objection letters, so we file the suits. I do those all on a contingency basis, which means, or for the most part, if I believe there's merit in the suit, then I do it on a contingency basis, or if I believe that it's fairly certain we will win. I do those on a contingency basis, which means that and I see a typo here, I'm sorry, that you don't pay. We file the lawsuit, and if we win, then the agency pays our fees, and if we lose, then we write the fee off. So you can challenge them. I know lots of reporters aren't aware that there are people that will do this for you. So that's the end. I'm going to go into Q&A. Joe, unless you think there's any pressing ones that I should do before this.
Yes. So we have two, really, I just muted you, so sorry, I was getting some feedback. One is actually for me, but I'll start with the one from RJG02, who asks, at the beginning, you said you are able to create, a throwaway email address and file a reporting case. You don't want the office knowing that it's Becky Green. Don't want them knowing that a reporter is asking these questions, but Becky asks, isn't it dishonest to not say that you're a reporter, and can it cause problems later on?
Well, so I think that's a question to discuss with your editors in terms of what ethical issues might exist for you. I don't particularly see one unless you are asking them for quotes or something along those lines. But in terms of just seeking public records, I don't see it to be an issue, but it's something I think discuss with your newsroom. It is one, and I know that there are some publications that have done this. It's a way just to get records with you're not asking them, in other words, for something that any member of the public wouldn't be able to get. So I don't think that there should be any specific concerns, but certainly discuss it, with those in charge of your newsroom.
Okay, awesome. And then the second question, I just had a question. You mentioned that you're required to request the specific documents and forms that are associated with particular files as opposed to requesting the files themselves. And I'm wondering if there are resources that you are aware of that allow people to go through almost like a menu and see if I'm requesting X type of file, I should expect, or if I need this documents from this file, what are the documents and files that I can expect to be associated with them?
Yeah, so that is the tricky one. And what I would say is, I always say to ask for something, even if you don't think you can get it, because some agencies will just give it to you. So, and especially when it comes to like, land use records and things like that, excuse me. Sometimes you can say, I would like the entire zoning file for that property over there, and they will give it to you. It depends. So I usually try to frame it like, here's a few documents I know that will be in that file plus the whole file. And then sometimes they give you more than what you enumerated. So one place that you can look is if you just Google NJ DARM, DARM, that will pull up I forget the official name now, the records retention schedules for the state. And so you can go through there, and they have schedules for different agencies. So there's municipal clerks, there's municipal police departments, county, state, there's just different schedules. And there's probably like 25 schedules. And if you go through them, that gives you there's a good way to see some sort of documents that they're required to retain. And that's a good way to find them. Other ways is, like I said, requesting an SOP, to see if standard operating procedure, to see if there's a specific type of record they're required to make by, pursuant to a policy, reviewing regulations that relate to that agency. If it's a state agency, you can say, let me see what regulations exist, because there might be a filing requirement there, either something they have to keep and maintain internally or something they have to file with the legislature. And then again, picking up the phone. There are some custodians that are just super helpful, and they will say like, oh, that's what you're looking for. All right, what you want to request is blah, blah, blah. And then you can send your request in.
Okay, just two more real quick. The first one is from Becky again. How long does it take to get executive/closed session meeting minutes after the meeting occurred? And then M. Catalini wants to know if you can talk a little bit about how best to request an OPRA log, specifically after you've received a response that was mostly rejected but did turn up several documents. It seems that they're curious to know how much was deemed exempt and whether it's possible to get more specifics.
Okay, I think I have a screen on the minutes already, so I'll save that one for when I get to the screen on it. For the OPRA log, I think I need a little bit more clarity on the question. Are you talking about the log of all of the OPRA requests that they receive and the responses to them?
You're unmuted. Go ahead, Catalini.
Yeah. Hey, CJ, it's Mike. No, I'm asking about. Well, I'm not sure if it's noted to your question, but I requested correspondence and was told that initially there were a bunch of them, but got only like 2 or 3 back. But I'm curious if it's possible to sort of, if they have to create like a log of everything that they turned up, just so I could see like how many exist, or if there's any more information about the correspondence that they're denying me, if there's a way that I could ask specifically for what that is, that's still, that sort of, that they would have to turn over to me, basically to show me what they turned up when they did the search for the emails that I had asked for.
Okay, so yeah, I think what you're saying is that you requested, documents with a certain keyword, and then they responded and said, here's 5 documents, and you want to know if they withheld anything and what basis, I believe is what you're asking? Yeah,
essentially, yes.
Yeah, so what they're supposed to do is, and not all agencies are good with this, so what they're supposed to do is say, your search turned up 10 emails, we are producing 3 emails, and like, here's the reason why we're withholding the other 7. And if it's different reasons, they're supposed to say, like number them and say 1, 2, 3, 4, 5, 6, 7. We're withholding number 1 and 2 because of attorney-client privilege, and number 3 and 4 because of this. But some agencies don't do that. They just say, here's 3 emails. And so I think what you would do in such a circumstance is respond and say, Can you please tell me, were there any emails that you withheld? And can you provide a privilege log or state the basis for the emails that you withheld? And, you know, use that as a starting place. You want to get to a point where you can determine whether it was lawful for them to withhold anything. And sometimes you need more information than that. But I think that would be a good starting point, is just to ask, what did you withhold and why?
Okay, that concludes our ad hoc questions for now. You can go ahead and move on to your slides.
Okay, so the first one was, how do you handle agencies taking extensions? And probably everybody on the phone, everybody on the line has a frustration with this. I know my clients deal with it a lot. It's very frustrating. I'm just gonna change my view a little bit here. Okay, it's very frustrating, and we're really sort of powerless in a certain way. So the plain language of OPRA really says that you can take extensions when a record is in storage or archived. But the courts have allowed the extensions to basically just be anytime. And so if an agency says, I want 7 days, you really can't do anything about it. Because if you tried to file a lawsuit, first, you probably wouldn't be able to get the lawsuit filed and the order back from the judge before they even produce the document to you anyway. And then second, just the way that the case law is, it makes it hard for you to be able to recover attorney's fees for having filed that lawsuit, because the courts would say, well, they told you you were going to get it in a week, so your lawsuit isn't the reason that they released it, so you don't get attorney's fees for reimbursed for your attorney's fees and court costs. So then you're out those dollars. So the way I handle it is sort of a reasonableness standard. Like, sometimes people do request a lot of documents, and if you're requesting something that produces hundreds of pages and there's something that would need to be reviewed for privilege, then that might warrant some more time. So what I say is always, you know, when you get an extension request, politely tell them that you object to the request. If it's just 7 days or 5 days and that doesn't matter to you, then fine, accept it. If they say they want 3 weeks, but you really need this, then, you know, try to offer something in the alternative. Like, how about I give you until Monday? How about I give you 1 week or 2 weeks? You know, try to negotiate a different response time if you can. Or you can offer to narrow your request. You can say, wow, I didn't realize that 3 months worth of emails was going to be 500 pages, so let me just do the past 2 weeks, and then you can always file another request. Or you can tell the custodians, hey, I understand that the bulk of my request is going to take 2 weeks, but I need this one particular document right now in order to do my story. So can you give me the budget and then work on those emails for next week? So there's different ways to try to handle it. In terms of challenging it in court, it's difficult until it gets to the point where it's clear. You know, for example, I've sued both the city of Newark and the city of Jersey City, because you just get, and the state police, because you just get these like, we need 2 more weeks, we need 2 more weeks, we need 2 more weeks. And it will go on for months. I've waited before to say, like, how long will this go on? And it'll be like 6 months later for a simple request, and they're still saying 2 more weeks, 2 more weeks. So, you know, there's just this gray area of when you can challenge it, but you kind of have to wait for, you know, until it will be clear to the court that it's unreasonable that they've taken an extension. How can I request email correspondence? And another one was, how can I request emails if you don't know the person's name that might be emailing with the government official, or a subject matter? So I'm just going to tell you what the sort of standard is in the GRC case law anyway, and some tips, and then my thoughts as well. So first is, you know, people get confused about whether something is subject to OPRA if it's used on a private account. So the test is, regardless of where they send the email from, whether it's their Gmail account or their government account, it is a government record and subject to OPRA if it relates to government business. So if it's, you know, if it's the mayor using the government account to email home about what's for dinner, that's not subject to OPRA, because it's not government business. It's just he or she is doing something personal on the government account. Conversely, though, if they're using the Gmail and they're talking about government business, you can get those Gmails. Now, the problem is that it's often hard to get the Gmails, because the clerk doesn't have access to them and you're relying entirely upon the government official that's using private email to produce them. But nonetheless, they are subject to OPRA. Government officials should not use Gmails, by the way. So the GRC has developed this standard, and this is the safest bet to ensure that you will get a response and the safest bet to convince a court that you deserve a response. But I think you can stray from it a little bit. So the GRC has said that a valid email request should have a sender and or a recipient. So you don't necessarily have to know both parties, just one. So you could say the mayor's emails. You don't have to know who the mayor's writing. A reasonable date range. And again, like I said earlier, people send often hundreds of emails a day. And so you want to keep your range really, really small so that you don't get hit with a special service charge request or some other delayed response. And then a subject and or content keyword. Now, this is where I feel like agencies sort of I get both sides of this response. So some agencies, the easiest way we all know to search an email box is to say keywords, right? I want you just to search the mayor's email box for any email that the keyword budget, right? So all they have to do is search the keyword, whatever it brings up, print it out or send it to a disk and then review it and give it to you. But some agencies will say, no, you have to give me the subject matter. And they'll try rejecting a list of keywords and then say you need to be describing something like regarding communications about the budget. And then other agencies will do the exact opposite and say, no, we need keywords. So it's really frustrating. So that's sort of like the general, and I always say ask that they search both server and private emails. That's sort of the general test. If you have those three elements, then they should comply with your OPRA request. You should be able to say, here's a list of keywords, here's the date range, and here's whose email box I want you to search. I'm pushing back and saying, I don't think that you necessarily need a keyword if it's a very narrow period of time. So I think you should be able to say, I want all of the mayor's emails that he sent yesterday. Now, I think I saw one unpublished case where that was sort of acceptable. That's something I'm pushing back on. That doesn't mean you're going to get a response if you try to do that. But I might be interested if you do when you get a denial. Here's one way around this sort of not knowing who the parties or subject matters are. There was a case 2 years ago, I believe it was, called Path versus Township of Galloway. The Supreme Court held that the log of emails that exists sort of in metadata within an email server, that information is also subject to OPRA. So I have clients that do this, or clients that have me file requests for this, that you can seek a log of the email box for a certain time frame, and you can have it. It will say the sender, the recipient, the date, time, and the subject line. You want to use a very narrow time period here because, again, it will produce a lot of paper, and you don't want that. So here's one that was someone requested from, I think it was the state police's records custodian. So you can see this is, kind of the general format of what it's going to look like, and you can look in there and say like, okay, rather than having to request all of the mayor's emails for a time frame and then having to go through all this junk that doesn't matter to you, you can say like, oh, that's the one email that matters to me. Now I can specifically request that email. So that's one way to request emails better.
2 questions real quick before you move on.
Okay.
Both from Jessica. Wants to know if members of appointed commissions are subject to these same OPRA requests laws as elected government officials, and what can be done if you believe that all emails related to an OPRA request have not been provided?
So for the commissions, honestly, I'm not sure. I believe they still would be. They might not be subject to the Open Public Meetings Act, but I believe they still would be subject to the Open Public Records Act. I think I would need to look at that a little bit more closely, but that's my general thought. Anything related to the sort of government business would be subject to OPRA. In terms of the pushing back about whether you believe they gave you everything, this is where either having an attorney involved would be helpful, because the attorney could request a privilege log and they might be more willing to give it. But you can do yourself. Say, I'm not sure if you gave me all of the records. Can you please tell me there's something what they call a PAF certification, PAF, P-A-F-F, as in John Paff. Many of us know John Paff. He's a big transparency advocate. He litigated a case about this sort of issue. And it's really a procedure for the GRC to follow it, but now the courts follow it as well. And so you can say, I want a PAF certification, and they're supposed to tell you, you know, generally what their search terms were, what documents it produced, and what they withheld and why. So you can ask for that, or a privilege log. You know, as in the case of most of OPRA, there's a certain level of trust, because in the end, we don't have access to their server to know what they are or are not withholding. If you have evidence that they're withholding something, then that might make for, you know, challenging it in court. In general, I don't like to bring lawsuits where the agency says they don't have something and the client thinks that they do, but there's no proof. I like to have some level of proof that they are withholding something more than mere conjecture. So the next question was submitted before was, can an agency deny records if they'd have to redact all or nearly all of the information in the document? So the provision of OPRA says that if there's part of a record that's exempt, they have to redact that part and give you access to the rest of the record. So sometimes agencies will try to just deny an entire thing, and we're like, no, there's only a small part of it is exempt. Now, if it's the entire document that would need to be redacted, then it would be difficult to challenge that in court if they just didn't give you a blacked out sheet of paper. But if it's just nearly all of the document, and there's some of it that's not exempt, then yes, they should give that to you, and they have an obligation to do so. Another question was about legal bills. If you want them to be sent to you by email, so this is really generic and as to all records, but you're told that there's only paper copies. Is that okay? No. So OPRA says that they have an obligation to give you a record in the medium that you want the record, and that access to electronic records is to be free. So except in the rare case where maybe the agency doesn't have a scanner, which it's hard to believe that any such agency exists, then yes, they need to give it to you in electronic format, even if they don't want to. So someone said, I heard the federal government changed public records laws to make it harder to obtain information. If true, is New Jersey OPRA affected? The answer would be no. Federal FOIA is a separate statutory scheme that applies only to federal agencies and not state agencies. The federal government could exempt some records from access under OPRA through federal statutes. If there's certain documents, for example, that states are routinely making and exchanging with the federal government, you know, the federal government, either through a regulation or statute, could exempt them from our records laws, because OPRA allows federal statutes to create exemptions. Many state agencies are beginning to use online platforms such as Cisco, Jabber, and Slack to communicate. I also had questions recently about WhatsApp. Are these chat logs operable, and what responsibility do organizations have to preserve them? So like I said earlier, chat logs are just like emails. It doesn't matter where they occur. If they're related to government business and it's a government employee or official doing the communication, then it's going to be subject to OPRA. But the biggest issue is with the use of private email accounts or private chats and encrypted information, is that the custodian might not even know that it exists, likely doesn't know that it exists. And so getting it, whether they should make it available and whether you will ever know about it is a whole other issue. There's no laws that I'm aware of that say they can't do this. And, you know, presumably they're subject to the state records retention laws, but I think the state records retention laws really also need to be updated to make it clear what forms of electronic communication need to be restored, how, and for how long. What are the different types of reports that someone could request for a police department to see all of the crimes that occur in a month? So as we discussed before, most police records are relating to crimes are going to be exempt. So that's a bummer. But there are some other ways that you could try to get this information. One is a blotter or an activity log. That's something that the police, they used to make them more frequently, but lots of agencies sort of still do publish like a local blotter in the local paper that will say this week we arrested these 5 people. Or they'll put it on, now they put it on their website, or they do press releases or some other form. So that's one way, is to request or look for the police blotter or activity log. Another way would be each week to invoke that Section 3B statute that we talked about, that gives you all the information about crimes that were reported or arrests that were made. So you can say, I want all of the information every week, say, I want all of the information pursuant to Section 3B for all reports of crime and arrests that occurred between the prior week. They should comply with that request. And another one would be to look for CAD reports for a specific time frame. The case law, CAD reports, you used to be able to get. The case law is like slightly murky. I think you should be able to still, and most agencies release them, but it's a little murky now.
Before you go ahead, there was this seems so irrelevant. I had a question. What are some other hypothetical circumstances or creative use cases that you're aware of in which requesting the metadata actually might be more useful or illustrative than just simply requesting the specific records?
So I haven't done a lot of metadata. I think probably a data journalist type person would be able to answer those questions more than I would. I can tell you that the metadata is subject to OPRA. So sometimes it's helpful, for example, if you want a specific document, to request the document in its original format, because then you can see the metadata within it in terms of like who owned it and when was it exchanged with other parties and that sort of thing. And Word documents can be edited before they give it to you. So you can.
Yeah, I'm thinking specifically in cases of location data for government cell phones, metadata at that level to sort of check, let's just throwing this out there, but check, for instance, where a government employee is spending their time during government hours, things along that nature. Is that a little too intrusive in your understanding, or?
Well, so I don't know. I haven't had that come up. I mean, I think it could depend on the type of employee. I think it'd be harder if it was a private citizen, then you could say that there's a privacy interest. I think it's harder to say for a public employee if it's, say it's just the head of the recreation department or something, and you want to see like, were they really at work all day? Because I know they also hold this other job, right? That's where it would come up. Right. There's some cases about telephone logs, like about higher level public officials, like county executives or mayors. There's some case law about like calendars and telephone logs, like you're not entitled to see like the list of who they called. So I suppose an agency would try to say that seeing like, where they traveled would be on par with seeing who they called, or security is always something that's raised. I know with the governor, there were cases that were denied, requests that were denied and not successfully challenged in court about where the governor had stayed on various trips before and how much resources was put into the security detail, or, Easy Pass records, trying to see like, is someone using their Easy Pass to travel all over to like campaign events? The higher up the chain you get, it's harder because then there's all these security arguments they start making. Unfortunately, because that's probably where that's more likely to occur.
Thank you.
So this one says, how can you find out what services a lawyer performs if the town doesn't have monthly legal bills because they pay a flat fee retainer to the lawyer? I guess I hadn't personally come across this because I mostly see legal invoices that are detailed. But the source I found on here was from the comptroller's office, and they talk about how lawyers have to bill local agencies. And so it is true that, you know, most of the time, most legal work is performed on an hourly basis. And so they will be breaking down like point 1, we did this, point 2, we did this. And those bills should come to you overwhelmingly not redacted. I've successfully challenged a bunch of cases where they black out redact them, and they can't do that. But there are some agencies, especially school boards, that will, or like zoning board attorneys or planning board attorneys, that will pay an attorney a flat retainer and say, we're going to give you $1,000 a month, but that covers you attending all of the monthly meetings all year. And then, so what this guidance said was that, you know, to find out what that would be, what's covered is you want to request the contract or the agreement or the resolution that would detail what exactly it's supposed to cover. And then you want to look and see if the attorney submitted any other hourly invoices as well, because they can't be duplicate. It can't be that they were paid by this contract for monthly meetings, but then they also submitted a hourly bill as well and included some stuff that fell within that contract. So you just need to make sure that they're two separate types of billings. If the contract says it includes attending meetings and drafting resolutions, then they shouldn't be billing on an hourly basis for drafting resolutions. All right, so the other one says, how long after a special closed meeting can you get the notes from the meeting or the minutes? And if there's a meeting about personnel, can a reporter ever get access to those from the meeting? So this is governed by the Open Public Meetings Act and not OPRA. And I will say that I know much, much, much more about OPRA than OPMA, only because OPRA has the fee shift, which means I can represent so many clients basically for free and litigate these cases, whereas OPMA suits, they're litigated far less frequently because it doesn't have a fee shift. So in order to challenge something, an OPMA violation, you need to pay an attorney or try to do it yourself. So in general, there's a lot less guidance on OPMA than there is OPRA. But anyway, OPMA says that meetings and minutes need to be promptly available. It's not defined, but courts have generally said that means approved at the next meeting and released after that. Now, and that would apply to closed session minutes too, although the closed session minutes might be redacted. And, you know, most agencies, you know, there's a few that are good on this, but many agencies, if not most, are behind on their minutes. So you might not get them for 2 or 3, 4 months. I sued an agency that didn't have the minutes from the meeting 3 years prior. Unfortunately, it kind of depends on when they approve them. I have litigated this issue and tried to argue that there's no requirement that they be formally approved and they should be released as soon as they're drafted, and I lost that issue. So we have no option but to wait for them to approve them. But there's going to be some information within the closed session minutes that might not ever be unredacted, and personnel issues might be one of them. So if they're discussing an employee's medical leave or, you know, some sort of performance plan, that's going to be exempt under OPRA, and you'll probably never be able to get more information about it. If it's something like a negotiation on a property or things like that, then that might be something that they would redact once the need for that confidentiality is gone. So this person said, in print, there was a corrections box. How do we deal with online stories to avoid legal issues and to be accurate? I don't feel comfortable answering this question because it's really both an editorial and a question and seeking legal advice. I think publishers should just generally be aware that, you know, there's this concept of what constitutes a publication and what constitutes a republication. And when something is published anew or republished, then that's a new statute of limitation. So you do have to be careful about going into an old article and editing content, because if you make changes that are substantive or material, that could be considered the equivalent of republishing it all over, and you open yourself up to a new statute of limitations. So if you ever get a request to edit a story that's, in particular, one that's more than a year old or close to being a year old, talk to a lawyer, talk to your editor, because it could be someone setting you up to re-trigger a statute of limitations for defamation. But that one's sort of outside the topic of this seminar. So this one asked for pretty in-depth information. Where can I go for water quality and lead pipe leaching information? This person is lucky because I actually have just been litigating for the past year and a half or so for the Natural Resources Defense Council, all of these lawsuits against Newark for records relating to the lead pipe issue within the city and the lead contamination. So I was able to know this information where, 2 years ago, I would have no clue where to start. So one starting point is this website. And it brings you to this little screen, and it allows you to sort of enter in information about a water system. So if you know where your city gets water, sometimes it's just the city's water. If you know there's a specific name, you can search and it will tell you some information about it, and if there's any contamination notices and that sort of thing. So that's on the NJDEP's website. So that's just one easy starting point. There's also, every water system is required to prepare these consumer confidence reports each year. And often they are on the water system's website. So if the water system is owned by the town, then you can either go to their website and try to find them. I Googled and found this one, but there was a bunch of other ones that came up. Or you can file an OPRA request for it, but it's going to be a report, and it's going to give you an overview, and then it's going to go into specific water testing results. If you go to Newark's, it's talking a lot about the monitoring results and how there was lead and that sort of thing. And then finally, you can submit an OPRA request with DEP and or your town. And I say and or because you might want to submit it with both, because DEP doesn't necessarily always get everything. So you can request any record submitted by your town's public water system for compliance with or non-compliance with the lead and copper rule is what it's called. And so they would produce to you, and the second one says monitoring results. So they would produce to you like the results of the recent monitoring and like other test information. And then you might also, specifically with regard to the lead pipes, you might want to request the corrosion control treatment and the lead service line inventory. And that will tell you like which houses have lead service lines and are they properly treating the pipes. And that was the big issue in Newark, was the lead pipes. Where can I find information about our cable company's local contract? This is another one. I reached out to a friend that represents cable companies to find this information because I didn't know. But so municipalities set the contractual terms with cable companies through an ordinance. There's the contractual terms are in that ordinance. There's not generally a separate contract, and it's generally called a municipal consent ordinance, and you can request it from the clerk, or it might be online on if your municipality's code is online. Evidently there's a lot of agreements that the cable companies might have with other people, such as utility pole owners. They have to have a contract to use the poles to the cable lines, and you can get those with the Board of Public Utilities. So this is a good question, I think, is how can lay people sound like we know what we're talking about when we're objecting to a denial? And I think that's important because, agencies should accommodate everyone of all knowledge levels and sophistication and education levels, but they don't always. Sometimes like the more sophisticated response gets them to take notice and comply with the request better. So what I say is, first of all, always be polite and professional. You're not going to get anywhere if you attack the custodian, as frustrating as it might be. It's also frustrating on their end because often they are not the ones in control of the records. Unless it's documents within their office, they're relying upon other public employees to give them the responsive records, and to, sometimes their emails to those employees are just sort of ignored. So always be professional and polite, and try to understand that they're doing, for the most part, most of them are trying their best to handle a difficult job. If possible, try to cite the statutory provision that you think supports your position. You don't have to necessarily cite it by legal citation. If you can, that's even more impressive to them, I think. But you can go to the GRC's website and they have like the actual OPRA exemptions there, and you can say, hey, I don't think this one applies. And if you have read about a case or something, you can say, I don't think it applies because of Paff versus Galloway. And just seeing legal citation might cause them to say like, oh, you know what, I should involve the town attorney. And then hopefully that gets you a better response. And then you can try giving the custodian a call and say, hey, I just received your email and I don't really understand what the denial is. Can you, I thought that blah, blah, blah was available to us. Can you tell me like why it's not, or what I should request instead? You know, picking up the phone doesn't hurt. Or you can always email me. I'm pretty good about getting back within a day or so. And I might be able to tell you my thoughts on whether something is exempt or not. So that's the end of the questions I had pre-prepared. I don't know if if there are new questions or any follow-ups.
You should be able to unmute yourself. I will go ahead and unmute our phone participants briefly if they would like to chime in. Looks like we have 413-588. Go ahead, you are unmuted. Anybody else that you can go ahead and manually unmute yourself. There's a button in the bottom left of the Zoom window. It should say mute. It should have your microphone with a little slash across it. Click that to unmute yourself, or press Command-Shift-A or Control-Alt-A or Alt-Shift-A. It should unmute you. But I don't see any more questions in the comments. Give a little bit more time. Does anybody else want to chime in? I'll mute everybody just to see.
Yeah. Or if there's any topic anyone wants to know more about, I purposely, you know, when I give this presentation to the public, I go more in depth about various exemptions and more in depth about drafting responses and that sort of thing. So if there's anything anybody wants to discuss further, I'm happy to do so.
Okay. Okay. Let's see. Oh, here we go. Joe Hernandez. I'm being ghosted by an agency right now. They're just not responding to me and they're way past the 7-day deadline. How do you deal with that?
So that's where I would say a little bit more follow-up. So if you've been emailing with them and that's the primary method most of us communicate anymore, and what I recommend, frankly, because I like to see all the communications in writing if possible, because then you can document it to the court. But if they're not responding that way, then I would suggest finding another form of communication. So that could be calling and if you know, keeping a log of your call, because maybe for whatever reason someone's not paying attention to their email, or maybe your email started going to spam, or sending a fax, something where you have some sort of confirmation that it happened. You know, it depends on the agency. Maybe you would say who the agency is, and I would say, well, that's just standard practice for them. But, you know, at some point you should discuss when to pull the trigger on a lawsuit if you've truly made numerous attempts and they're not complying with your response, with your request. You just have to keep that 45 days in mind so that you don't end up waiting like 6 months and then having to try to sue and that sort of thing.
Okay. Just remember, we do have CJ until 2:30. If anybody wants to go into a little bit more depth, this is the time to get into the weeds. Don't worry about derailing the webinar or the rest of the group. It seems like we've had a sort of a natural lull. So if there was that question that you were just, you didn't want to be rude or imposed to interrupt the flow, this is the time to do it. Otherwise, we'll wait a couple seconds or minutes and we will let everybody get back to, I'm sure, what I'm sure is incredibly busy Monday. Okay, unmuting the phones just again.
And I just want to let everybody know, I do publish a blog. I know a lot of people do already read it, but it's njopra.com. I try to discuss, you know, new cases that come out. I try to provide practical tips, especially if you look at older blog entries. Some of these screens are in there in some format where you can, you know, if you're not sure how to draft a certain request or how a certain exemption applies, I probably discussed it in some form on the blog. So I try to keep it updated. Sometimes I get a little behind just because I'm so busy with my practice, but you know, I try to let you go on, and you can also follow me on Twitter. I try to tweet topics that are public records topics as well.
I actually have a really quick question, and I'm going to put your Twitter link and everything, all the links in the chat as I've been doing. The cost of OPRA requests, maybe not for some of the larger organizations, but I know that multiple times I've heard from some of our smaller and hyper-local publishers that somewhat of a deterrent to, you know, maybe filing these sort of larger requests, or maybe even unearthing some of these more, you know, groundbreaking stories, is the fact that they can cost money. I know you said that the digital email version is free, but do you know of any solutions, or even, you know, collaborative solutions, for instance, to offsetting those costs? Are there funds or grants that you know of that might be able to help with that? And if not, you know, could you talk a little bit about where that comes from and what people might be able to do to mitigate that cost?
Yeah, so I'm not sure of any funds or grants. The primary cost that comes with OPRA requests is generally the special service charges, and they're generally for very large requests that require either them to hire for a larger complex request that requires them either to hire some sort of outside IT professional because they don't have anyone in-house that could handle that. And I truly mean, I see agencies try to pull this sort of stuff with requests that do not rise to that level. So for example, for one of my clients, they requested the list of banned users from the town's Facebook account, right? And the agency tried to charge $200 to capture the screenshots of those banned users list. And so we sued, and the court said that did not require any special technical expertise or an IT professional to do it. So basically what I'm saying is a lot of what they try to charge isn't something necessarily that they can charge. And if you push back and you know, look deeper into what it is they're charging, then you can often get them to remove those charges. And then the other thing is, you know, again, narrowing your request is one way to sort of avoid them. So if your request, it might take you a little longer, but if you don't have the funds to pay for that huge document production, narrowing the request and getting pieces of it at a time can help you avoid that. So those are the main tips. There's inevitably going to just probably be some larger requests that, you know, unfortunately you might not have the budget for. But in my experience, most requests you can whittle it down in some way to make it accessible to you for either free or cheap.
Thank you. And we did have one person who just joined via phone. It's a 908 number, 908-977. You're joining towards the end of the call of the webinar, but do you have any specific questions that you want to throw out there before we run out of time?
No specific questions.
Okay. Okay. Well, then I think that'll do it for today's webinar. Obviously, thank you so much, CJ, for this. This is incredible. I have so many little threads that I want to follow up on and try things out. If anyone wants to get in contact with CJ, the contact information was up there. I will also follow up with a recording from today's webinar, a rough automated transcript that is searchable that will help you, you know, search to a specific spot, as well as the record from the chat, including all the links and everything that we put in there. CJ, any final words?
No, I think that OPRA is a really important tool. It's good for journalists to use it. It's always surprising to me when I will meet a reporter that I haven't met before, and they will say, oh, you know, like I didn't really know much about that you could get these government records from people. Or I'll talk to reporters that I do know, and they'll tell me that like other people in their newsroom like really don't know anything about OPRA, or they just constantly get these denials and they don't challenge them. And I do think it's important for reporters to challenge denials. I know I've had newspapers that I've represented where they just had towns that would never take their OPRA requests seriously. They would just ignore them. And then after we would sue the town like 4 or 5 times in a row, then all of a sudden their requests were taken seriously and they haven't had issues since. So sometimes the agency, they just fall into this habit of knowing like, oh, that's just Tom filing his OPRA request, but like he doesn't do anything about it if we don't give him what he wants. And showing them that like, no, you do have someone on your side that can help you get the records and you are going to push back. We'll show them like in the future, okay, we're going to take your request seriously and respond to it. So I'm happy to help. People can shoot me an email or send me a message on Twitter, and I will get back in touch with you.
All righty. Well, thank you again to everyone for joining us. Thank you to CJ for leading this. Thank you to Liz for helping set this up. And this will not be the last time that we work with CJ here at the center. So I really hope you spread the word that about what you learned here, and that we can work with you and your colleagues in the future. So thank you, everybody.
Thank you.
Have a great day.